The writ of habeas corpus extends to all cases of illegal confinement or detention by which any person is deprived of his liberty or by which the rightful custody of any person is withheld from the person entitled thereto. The purpose of the writ is to inquire into all manner of involuntary restraint and to relieve a person therefrom if such restraint is illegal, to obtain immediate relief from illegal confinement, to liberate those who may be imprisoned without sufficient cause, to deliver them from unlawful custody. Actual and effective, and not merely nominal or moral restraint is required. However, actual physical restraint is not always required. Any restraint which will prejudice freedom of action is sufficient. The Supreme Court, Court of Appeals, and the Regional Trial Court have concurrent jurisdiction to issue the writ of habeas corpus. Family courts have jurisdiction to hear the petitions for custody of minors and the issuance of the writ in relation to the custody of minors. The return must be made by the person or officer who has the person under restraint, or in whose custody the prisoner is found.
So what is the difference between a preliminary citation and peremptory writ? A preliminary citation requires the respondent to appear and show cause why the peremptory writ should not be granted. On the other hand, a peremptory writ is a written document which commands the respondent to bring the detained person before the court. For the quantum of proof for the issuance or non-issuance of the privilege, the respondents carry the burden to prove by clear and convincing evidence that they have released the detainees when such release is disputed by the petitioners and it is not denied that detainees have not been seen since their supposed release. The writ is not proper on the following cases. When is it proper then?
Writ of Habeas Corpus in relation to the custody on minor. It is a petition filed by any person claiming for the rightful custody of a minor when such rightful custody has been withheld from the petitioner by the respondent and that it is the best interest of the child concerned to be in the custody of the petitioner. Where to file? It must be filed before the family court of the province or city where the petitioner resides or where the minor may be found. It may also be filed with a regular court in the absence of the presiding judge of the family court. It may also be filed with the appropriate regular courts in places where there are no family courts. It may also be filed with the Supreme Court or Court of Appeals or any members, and if so granted, the writ shall be enforceable anywhere in the Philippines. Pre-trial is mandatory. If the petitioner fails to appear at pre-trial, the case shall be dismissed unless the counsel or representative prove a valid excuse for the absence. If the respondent filed his answer but fails to appear at pre-trial, then the petitioner shall be allowed to present ex parte evidences, and the court shall then render judgment on the basis of those pleadings and evidences presented. Failure to file a pre-trial brief has the same effect as failure to appear at pre-trial.
A writ of amparo is a remedy available to any person whose right to life, liberty, and security has been violated or is threatened with a violation by any person or entity. It covers extralegal killings and enforced disappearance or threats thereof. Habeas corpus, on the other hand, merely extends to all cases of illegal detention or confinement. Writ of habeas data is only designed to protect the image, privacy, honor, and freedom of information of a person, while a search warrant is only for the protection of the people from unreasonable intrusion of the government. Who may file? The following may file. First, the aggrieved party. In the absence thereof, any qualified person or entity in the following order. First, any member of the immediate family of the aggrieved party. In the absence thereof, the ascendant or descendant or the collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity. And lastly, any concerned citizen, organization, association, or institution. Where to file? You may file in RTC where the acts occurred, in the Sandigan Bayan, in the Court of Appeals, or the Supreme Court. These are the contents of the return. Number 1, lawful defenses of the defendant. Number 2, the steps or actions taken by the defendant to determine the whereabouts of the aggrieved party. Number 3, all relevant information pertaining to the threat. Number 4, the return shall also state matters that are relevant to the investigation. And number 5, the respondents, if a public official or an employee, should also state the following. If the respondent failed to file a return, the court shall proceed to hear the petition ex parte.
All defenses shall be raised, otherwise they shall be deemed waived. Although this is a summary proceedings, the court may call for a conference to simplify the issues. Decision must be rendered within 10 days, and it is appealable within 5 working days. If the case is archived, it will be dismissed after the lapse of 2 years. When a criminal action is filed subsequent to the filing of a petition of the writ, the latter shall be consolidated with the former. As to interim reliefs, the court may issue protection order in favor of the petitioner or protection in favor of a witness to the case, but only through verified motion and after due hearing that the court may issue inspection order or production order in favor of the petitioner. Inspection or production order can also be availed by the respondent through a verified motion and after due hearing. The parties shall establish their claims by substantial evidence. Hearsay evidence may be considered if required by the unique circumstances of the case. A public official must prove the performance of duty is done with extraordinary diligence. If the allegations in the petitions are proven by substantial evidence, the court shall grant the privilege of the writ, otherwise the privilege shall be denied.
Writs of habeas data. It is a remedy for any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. Purpose: an independent and summary writ designed to protect the image, privacy, honor, and information and freedom of information of an individual, and to provide a forum to enforce one's right to the truth and of informational privacy. The availment of the writ requires a nexus between the right to privacy on the one hand and right to life, liberty, or property on the other. It protects a person's right to control information regarding oneself, particularly when information is being collected through unlawful means for unlawful ends. Who may file? Any aggrieved party may file a petition for the writ of habeas data. In extralegal killings and enforced disappearances, any member of the immediate family, any ascendant, descendant, or collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity may file. Where to file? At the RTC, upon the option of the petitioner, where he resides, where the respondent resides, and which has jurisdiction over the place where the data or information is gathered, collected, or stored. At the SC, CA, or SB, when it concerns public data files of government offices.
The petition and the return shall contain the following matters. A verified written return shall be filed within 5 working days from service of the writ with the supporting affidavits. It shall be returnable to the following. If the writ was issued by the SC or any of its justices, it is returnable before the court or any of its justices, or the CA, the Sandigan Bayan, or the RTC where the petitioner resides. If it was issued by the Court of Appeals or Sandigan Bayan or any of its justices, it is returnable before the said court or any of its justices, or the RTC where the petitioner resides. If it was issued by the RTC, then it is returnable before the said court or judge. In case of failure to file a return, the petition shall be heard ex parte. The procedure is summary in nature, but the court may call for a preliminary conference. the court shall render its judgment within 10 days from the time the petition is submitted for decision, which may be appealed to the Supreme Court under Rule 45 within 5 days. In case a criminal action is subsequently filed, the petition for the writ shall be consolidated with it. If a criminal action has already been filed, no separate petition shall subsequently be filed. However, the filing of the petition shall not preclude the filing of a separate criminal, civil, or administrative action. And lastly, in a petition for a writ of habeas data, the quantum of proof required is the substantial evidence of the actual or threatened violation.
The lupon shall have the authority to bring together the parties actually residing in the same city or municipality for amicable settlement of all disputes. All disputes are subject to barangay conciliation. Prior recourse thereto is a precondition before filing a complaint. Dispute between persons actually residing in the same barangay shall be brought before the lupon of the said barangay. Disputes involving actual residents of different barangays within the same city or municipality before the barangay where the respondents or any of the respondents actually resides. Disputes involving real properties or any interest therein before the barangay where the real property or the larger portion thereof is situated. Disputes arising from the workplace before the barangay where the workplace or institution is located. Objections to venue shall be raised in the mediation proceedings before the punong barangay. Otherwise, the same shall be deemed waived.
When may the parties go directly to court wherein barangay conciliation is no longer necessary? First is when the only contending party is the government, its instrumentality, or its subdivision. Second is when any of the parties is a juridical person. Third is when the dispute involves parties or real properties in different cities or municipalities. Fourth is in an action for annulment of a compromised judgment. Fifth are in cases which involve offenses in which the law prescribes the maximum penalty of imprisonment exceeding 1 year or a fine of 5,000 pesos. Six are disputes arising from comprehensive agrarian reform law or labor disputes. And lastly, 7, other disputes wherein legal action is necessary to prevent injustice from being committed or further continued.
All amicable settlements shall be in writing, in a language known to the parties, must be signed by the parties and attested to by the lupon chairman or pangkat chairman. In case the party claims that the consent was vitiated by fraud, violence, or intimidation, it may be repudiated within 10 days from the date of the settlement. Remember, failure to repudiate the same within this period, it shall be deemed a waiver of the right to challenge the settlement. Also, upon the said 10-day period, settlement attains the status of finality and it becomes the ministerial duty of the court to implement and enforce it.